Terrible news, everybody. Out of Florida, there's going to be continued vertical integration. A case was just handed down from the Florida Supreme Court. It looked like it was written in crayon. So we're going to talk about it today on this episode of... Hello, my name's Tom. I'm a lawyer, and I was also a caddy. And had I not won that scholarship from Judge Smales, I may not have gone to law school. But fortunately, I did. And if you need anything, go ahead and follow me at Cannabis Industry Lawyer on Instagram. And then my website is cannabisindustrylawyer.com. Today, we got word that the Florigrown case is not going to pass, and therefore Florida shall remain a vertically integrated uber super millionaires club. The slight upside is because there are so many Florida patients now, there may be more super vertically integrated, very, very expensive licenses, but it'd only be a handful. So it's an incredibly terrible day for America and also for cannabis connoisseurs and entrepreneurs in these sunshine states. So sorry that it happened. Let's go ahead and start reporting on the news. This one comes from FloridaPolitics.com. A.G. Gararski is reporting that a 54-page ruling offered a sobering message to the challenge of the law's implementation. It upheld the structure of the booming cannabis industry, which is unfairly booming. It's only booming because people like weed, and there's only like 4 people that are allowed to sell it in Florida. Trulieve sells 50 cents on the dollar of every cannabis product in the state. That's terrible. Having considered the certification question together with Florigrown's special law-based challenge to 319868, they hold that Florigrown has not demonstrated a substantial likelihood of success in the merits of any of its constitutional claims. Accordingly, as fully explained below, we quash the first district's decisions. Now, this is a quashing of an injunction that the lower court had. That's just some fancy legalese that says the lower court stopped the state from doing something at a higher level, and then the state appealed that stoppage up to the Supreme Court, which then said, you know what, state, you're right. Get out of here, people that are trying to create a whole bunch of different cannabis licenses and open the state up so that it could actually support small businesses and entrepreneurs and other people besides Trulieve. It's just a terrible day for America, especially if you're in Florida. Florida's rigged. That's essentially what it is. If you want to get one of these licenses that's going to be coming online and you have $50 million, first, go buy some Bitcoin until you have $75 million. Then I want you to take that $75 million and tell the state of Florida that you have it. And then I want you to make sure that you write a check for at least $50,000 to Governor DeSantis's Political Action Committee. And after that, you may have a chance of getting one of those 6 new licenses that might be coming down eventually. Why might there be another 6 licenses coming down? Because they... This is from a lobbyist who represents cannabis interests. They're hopeful that the department, that means the state of Florida, will move quickly in their rule development for competitive bidding of 15 licenses with another trigger of 4 once we hit 600,000 registered marijuana patients, which is on the horizon. So as medical marijuana becomes more popular in Florida, it triggers these MMTCs, which are medical marijuana treatment centers. Those are the vertically integrated licenses that they award. If you are in Florida and you want to legalize weed, awesome. In your next ballot initiative, which remember has to get 70% of the votes, you need to be explicit to the extent that you can while still being single purpose on the question that it is going to be an open, unlimited license to the extent that you can, or you're going to have to start buying politicians in Florida and then telling them that if they pass your law, they will get something, because evidently Florida is one of the most corrupt states, and that's coming from me, a caddy from Illinois. Anyway, we also do have the opinion. And so if you want that, let me just link it to the people that are in there in the comments. And I'll also, I put one of them on the description. The problems with the description is YouTube doesn't like that we advocate for the policy change for appropriate regulation of the cannabis plant. And sometimes they try to shut us down if we put links in our descriptions. At least they did in October, but there's not an election in November. So this is, Florida Department of Health et al. They're the petitioners. They're like, hey, fuck you. other people who actually want a cannabis license. And Florigrown's like, hey, fuck you, state. It says, or, and by the way, you have created a statutory rubric that allows a very insular and special class of multimillionaires who reside in Florida to be able to access this public right to sell weed. So we can go through it. It is 54 pages. The one that I want to see most probably has to do with the dissent that they mentioned, because I don't see how this is not a special type of purposes law. To the extent that the Supreme Court said that it's not, I need to read that, and this is going to take time, and I don't want to like just sit there and be like, fascinating. Not the best, hey, let's get a whole bunch of dead air. Anyway, I do want to go down to the whatever dissent that she had, because I just don't see how they could say that it needs to be vertically integrated, and that is not a violation of what the statute, or I'm sorry, that the amendment said, where they clearly used the word or instead of the word and, or that the legislation that they have created is a special purposes legislation. And here's the one on statutory license caps. They are based partially on factual finding that the statutory caps have made medical marijuana unavailable or insufficiently available in this state, and partly on a legal conclusion that statutory caps are unreasonable in the light of the amendment's purpose. We disapprove of these rulings because competent substantial evidence does not support a finding that the statute has made medical marijuana unavailable, and the amendment does not preclude on a limit of the number of MMTCs that can be licensed. So they say that there's an unlimited number of these. The only limit really is going to be, do you have enough money to get it? Nobody has enough money to get it. I mean, I understand that some people do. It's approximately 8% of the population has more than $1 million. So what percentage of the population has more than $15 million? It's less than 1%. So if your state has set up its statutory rubric for regulating cannabis in such a way that the only people that can access the license are those that have $15 million, they have effectively made a regulatory system for regulating the cannabis plant that only applies to a fraction of the top 1%. Meaning that you're going to have to be a corporation. You're going to have to raise money, and you're going to have to go to that capital window and start saying you should buy some True Leaf stock. And then don't forget to go to any True Leaf store in Florida and buy our crappy flour. I really do want to try the black tuna stuff, though. All right. Remember, this is like terrible. Oh, there it is. The special purposes clause. Special law challenge. Florigrown's last claim on the merits of subpart B, yada, yada, is that Florida, because special laws granting privileges to private corporations. The trial court found that Florigrown has a substantially likelihood of success in the merits of these claims. Again, we disagree. This is the politicization of the judiciary. I'm sure that the judiciary has been appointed by all those crazy Republican governors that have come out of that state, including DeSantis, which is, of course, Italian for bribe. And, it's fun. Again, we disagree. So terse. I bet this is going to be some very terse legal analysis here. The statutory provisions that Florigrown challenges as special laws granting privileges to private corporations are the following. There's one where it's the medical marijuana treatment centers. 2, the department shall license as MMTCs. I'm not going to sit there and babble over medical marijuana treatment centers. 10 applicants that meet the requirements of this section under the following parameters. As soon as practical, but no later than such and such date, the department shall license any applicant whose application was reviewed, evaluation, and scored by the department, and which was denied a dispensing organization licensed by the department under the former's particular statute from 2014, which had one or more administrative or judicial challenges pending on such and such date. On the final ranking within 1 point, the highest final ranking in the region's Florida statute, which meets the requirements of this section. You see, it's just not very fun when you have like a lawyer reading an opinion, which provides documentation to the department and has existing infrastructure and technical ability to begin cultivation of marijuana within 30 days after registration as a medical marijuana treatment center. I guess that's all these things mean that the only people that can access it would be private corporations. So Article 3, Section 11A12 of the Florida Constitution provides there shall be no special law or general law of local application pertaining to private incorporation or grant of privilege to a private corporation. Thus, to violate this provision, a statute must have two features. One, it must either be a special law or a general law of local application. And two, it must grant a privilege to a private corporation. We conclude the challenge provisions are parts of general laws implementing a statewide regulatory scheme and accordingly do not violate Article 3, Section 11A12 of the Florida Constitution. That was blisteringly meticulous legal conclusions. They just said, we conclude. So, like, talk about a conclusory pleading. And that's one of the times that it's nicer to wear a robe as opposed to a suit to a court hearing and be the judge instead of a lawyer, because a lawyer can't make a legal conclusion so brazenly. And it's in either its allegations in the complaint or any of its presentation of the case, and that the court can use the word "we conclude." It doesn't. And to say that it's this general scheme to regulate it kind of overlooks the fact that the only people that can get into this general scheme must have had over $15 million or probably over $50 million. So one guy has $50 million, and that guy would, within 30 days of registering for his MMTC, be able to break ground and start construction. Fucking full of shit, man. You guys in the Florida Supreme Court are just terrible. Well, again, like, you remember those good law schools in Florida? My sister went to one. The Florida Constitution defines a special law as a special or local law. This is a very similar thing. These special laws are being litigated right now in whatever state has a licensing scheme, just like in Florida or in Maine or in Illinois, where only this insular minority of people can access this publicly granted right to make money in cannabis. It's only going to social equity veterans in Illinois or corporations that have $50 million in Florida. A special law is one relating to or designed to operate upon particular persons or things, or one that purports to operate upon classified persons or thing when classification is not permissible or the classification adopted is illegal. Essentially, these special laws are extensions of the 14th Amendment's right for equal protection. Additionally, in consideration of the constitutional requirements that a special law not be passed without either notice or a referendum, the court has made the following observation. The term special or local laws as used in the Constitution refers ordinarily to laws relating to entities' interest, rights, and functions other than those of the state, since the organic law does not contemplate or require previous publication of notice of proposed laws for the exercise of state powers and functions, though they may be more or less local or special in their operations or objections. A law that addresses state interests and operates to protect those interests using valid classifications based upon proper differences which are inherent in or peculiar to the classes is a general law. Even if the law is limited in direct application, it's still a general law so long as its application bears a reasonable relationship to its statewide purpose. Evidently, one of the statewide purposes of the medical cannabis law in Florida was not the eradication of the illicit market. When you legalize cannabis in your state, make sure one of the stated purposes of the law is the eradication of the illicit market. And that's why you have unlimited licenses. And that's why you have lower barriers to entry, so that all the cannabis that's in there has been taxed and tested. So you know it's safe and you've collected all the revenue that the state is entitled. The law at issue here appears to be satisfying these criteria, and Florigrown has no substantial likelihood of proving otherwise. Finding a law general where it applied to 5 tobacco companies in such a way as to protect funds used for statewide programs. So that would be an interesting one. R.J. Reynolds has tried this special purposes law, or Hall did, depending on who sued who over that. But finding a law general where it applies to only 5 tobacco companies in such a way as to protect funds for statewide programs. Florigrown contends that the challenge provisions constitute special laws because they operate on closed classes. Indeed, we have often held the closed nature of a class affected by a particular law indicated that that law was special. Holding that the statute was special law because it created an impenetrable barrier to all inter-tract wagering applicants except one. Remember, one company in Florida owns 50% of the cannabis market. In determining if a reasonable relationship exists between the statute's purpose and the classification it uses, the fact that matters is that classification is potentially open to other tracts. However, we have not held that every statutory operating on a closed class constitutes a special law. You see, they just did not want to find it. And that's one of the nice things about courts, aside from their ability to use legal conclusions, is that they can comb through a lot of case law, especially in very novel laws like the cannabis laws, to get it to say whatever the F they want. And if you don't like that, consider smashing those likes and clicking subscribe, because we'll be here reporting on cannabis laws the way they should be. On Wednesdays and Sundays, and on days when I have time, and then this kind of crap happens. I was really looking forward to working in Florida. I might get the chance. However, when there's only going to be a small handful of licenses that are that vertically integrated, I need to move to Tampa already and just like start hanging out at the Millionaires Club and being like, you too? Well, I'm not, but it's nice to see you. Hey, would you like a cannabis license? It's just sad, because then after these millionaires already get their cannabis license, suddenly once somebody has a lot of money and they have a cash flow that gives them a lot of money, they are fine. They don't need more licenses. And that's one of the reasons why I think a lot of the MSOs don't operate in Oklahoma. Because, what are they going to do? Are they actually going to go compete where the game is not rigged? People like to compete in rigged markets. It's not fair, but evidently it's also not a special law, according to this. Again, dead air is not good. Fortunately, this is on YouTube, but still. There's another one that's toward the end, and so there's the conclusion that they say that Florigrown does not have a substantial likelihood of victory on the merits on this. I bet if we looked up all these judges right here, the vast majority of them would all be Republican appointed. So I'm not saying they took bribes. I am saying that they made a decision that allows the billionaires in Florida to keep that cash flow and not share it. And so Lawson filed a special kind of dissenting where she agrees with the opinion, but she wanted to make some other aspects of it regarding what we had just gone over. Remember that one time when the Supreme Court of Florida today concluded that it wasn't a special law? Well, you see, the dissent disagrees with that aspect of it. She says, unlike the majority, I conclude that Florigrown has demonstrated a substantial likelihood of success on the merit of its challenge, this section, and then that one regarding the specific statute, and then also the amendment to the law itself that was on the ballot initiative regarding MMTCs as special laws granting privileges to private corporations in violation of that special law's prohibition. And according to the Florida Constitution, is cited right there. As stated by the majority, a violation, and then she goes through the two elements again. And then because the law grants this clear benefit to private corporations. Let's see what the clear benefit of private corporations is, according to her. The provisions in question, and then she cites the sections, grant certain private corporations described so precisely that they might as well be named in the statute the right to an MMTC license without entering the competition that others must enter for a statutory cap number of license. Because the law grants this clear benefit to these private corporations, it violates Florida Constitution unless it can be properly construed as a general law. So that's too bad that the dissent did not win the day. And again, people have opinions. You're allowed to have them. But if you're not in the majority, it doesn't matter. So there was one dissenter that said that they violated the special law that prohibits giveaways to corporations when they could have made it a general law. The later inquiry is straightforward in this case. A privilege is a right, benefit, or advantage. And yeah, I mean, if you read those statutory sections that are higher up in the opinion, if you want the opinion, here is another link because everybody's been burying it in comments. So there's the opinion again, sent that out. I'll try to put it into the description section. I have to be careful because Google owns YouTube. So Google doesn't like it when I put links into things, and sometimes it'll violate their terms, they say, and then they'll yank the video and ground us for a few weeks. And then I have to go back to relying on my caddy salary, which is meager, by the way. Us people over at Bushwood, we might be replaced by golf carts. So she goes on like this. With her case law firmly established with limited exceptions not applicable here, but discussed below, a statute that operates on a closed class is a special law. And then she agreed with them that it was a special law as well. I agreed with them it was a special law. You could say that I'm biased because I want an unlimited number of licenses in an open market so that people like you can actually get a cannabis license and go into business. Holding the statute was a special law because it created an impenetrable barrier to intertract wagering, except for one. So yeah, she read the same thing that the majority read, but concluded a completely different result. And that's just how it is with courts. And that's why courts are very important, because people have prejudices, including judges. And so those judges are going to vote by their prejudice. And that's probably what happened in this one. This clear principle of law makes sense. All right. So in this instance, if this one vote would have been, I don't know how many judges are on the Florida Supreme Court. I think it's 7. Does it say on this one? Nope. It just says lower court holding 54-page ruling, but then also unanimous. 6 of the 7 justices. So it is 7. So the ruling was unanimous, and 6 of the 7 justices sign on. Justice Alan Lawson wrote a partial dissent focusing on special rights to the class of medical marijuana corporations. So that sucks. The Tampa-based Florigrown's arguments, boy, those guys are sucking lemons right now in Tampa, aren't they? And you know what? Those kids in Tampa, they need to cut a check to Ron DeSantis. And actually, no, don't. Vote him out. Vote all of the other people out that are making it rigged. And then legalize it in Florida so that it is open, and then the licenses are limited by regulations like they do in they do it in Massachusetts, Michigan, and California, and then have the municipality set the number of licenses, not the state, so that you can get in where you can fit in, provided that the municipality wants you, and the state just acts like a regulator setting the rules, and then you have to get up to those rules, which can be quite expensive. Opening a grow will still be in the millions of dollars, but at least you can do it, as opposed to what you have now, a cartel, mostly owned by Trulieve, which you can buy stock in. So anyway, bad news out of Florida. News so bad out of Florida, it almost makes you just want to go, holy crap, what happened to our technical difficulties bumpers? Found it. There's our technical difficulty bumper. Anyway, hopefully you guys all have wonderful Memorial Days shaping up. Really sorry about the Florigrown case making Florida something that, I was really looking forward to moving to Florida and helping a whole bunch of people open up licenses. But now I'm just going to be sitting here helping the Eastern Seaboard open up a whole bunch of licenses, and then some of the South. And then eventually Illinois might actually award licenses. This industry is crazy. And I hope that you guys have been enjoying it. And I will see you on another episode of Cannabis Legalization News when it is of always, and of course,